if I know that this party is being funded by companies who are getting benefits from this political party, then I know that this particular party is corrupt because it is essentially getting a quid pro quo. And I suspect, and I'll show the figures. The figures about electoral bonds show that number one, they are almost all in denominations of 1 crore. So they are being largely purchased by corporates, etc., companies. Number two, they are essentially only being given to ruling parties. Bulk goes to the ruling party at the center, more than 50%. Remaining go to ruling parties in the states. And virtually nothing by way of electoral bonds goes to parties which are not ruling parties, either in the center or the state. I'm only showing this to show that one of the justifications given by the government for introducing the electoral bond scheme was, they said that, look, we are introducing this anonymous instrument of funding political parties because donors are reluctant to disclose who they are funding to. So we asked this question, was any representation received from any donor whatsoever that, look...
No, but you don't have to have a representation from a donor to perceive that reluctance. I mean, we're just trying to analyze, RTI response really will not carry your submission any further.
No, I'm saying that government should have some...
There's an assumption that, look, if you disclose the name of the donor, there'll be other political parties who will know that you have contributed to this political party, and therefore they might be subject to, suppose the donor is carrying on business in the state. If the name of the donor is made available to all the political parties, the rival political parties will say, well, or especially if you are making a contribution to a party which is not in power.
Only fear would be from the party.
That's the logic. Okay. Whether it's valid or not is what we have to decide.
Correct. Now, Your Lordship may come back to my written submission. I just want to show...
Prashant Bhushan, you're on... The first argument was right to information under 19...
I'm coming to that. I just wanted to lay out the few other factors.
Now let's look at the material what you are supporting.
Interim orders, my lord, two things.
Yes, let's see the interim orders. Where are they?
Page 15, bottom.
Volume?
Volume 1. Pausing here, my lord, I pointed out that the political party can well turn around and say we don't even know. I'm saying that, and ultimately, my lord...
The purchaser of the bond may not be the person who is actually handing it over to the political party.
That's right. That's why they may say that we don't know. And they can also say that it was not even handed over in person. It was just left at our doorstep. So, or couriered to us. Anything they can say.
Who's the election commission is appearing before us?
Yes. I'll just read out.
Who's appearing for the election commission? Mr. Sharma, you have details of this data which has been submitted pursuant to the interim order.
But this is pertaining to 2019. That interim order was passed in 2019. So pertaining to that, the data is with us.
But they should give the data. This was a continuing interim order.
But this is not only confined to the 2019 election. The mandate is that you must continue to maintain this data.
Because if my laws requires...
So, Mr. Sharma, let's be very clear. This is an interim order.
That's right.
It will continue till the decision.
So there are 40 legal lawsuits.
Pausing here, my lord. This is not correct because you can't, a citizen can't do this match the following, etc. Because the company does not disclose who they have given the bond to. Company only discloses the total bonds purchased. The political parties only discloses the total bonds received. So you can't, no citizen can match. Only the state bank, State bank and any law enforcement agency which asks such information from the state bank. Strictly speaking, only that. Otherwise, citizens certainly can't. It completely defeats the citizens' rights. Now, my lord, I just want to read out the objections of the Election Commission. Para 25. It makes no difference in my respectful submission. Because the political party earlier said that we have received X crores from 20,000 or less. Now they'll say we have received the same X crores from 2,000 or less. If they don't want to disclose those cash donations, they don't have to. So it's not going to make any substantial difference whether the limit is 20,000 or 2,000. With no other business of consequence having disbursable profits. So the Election Commission had pointed this out, that look, you are doing this, but this will open up the gates to shell companies being used to donate money to political parties. I was just reading the last paragraph of that EC's letter, para 6 at page 469. Increased use of black money for political funding through shell companies. As I said, my lord, what could be happening is that, let's say, one of the allegations in that Adani matter is that the money which was siphoned out by over-invoicing to companies which are registered in tax havens was thereafter funneled into these companies. Now, suppose, my lord, that money is now funneled through a subsidiary to political parties. That's really black money. It's really black money and, in a way, foreign money, which is coming to political parties through these shell companies which have been set up as subsidiaries.
Now, Mr. Bhushan, we go straight to your formulation now.
Yes.
I think we've seen the scheme, we've seen the
RBI reply.
RBI reply, perhaps, to make sure, so that they now can formulate. So then we can go to Mr. Sibal.
The government has not received any concerns from the Election Commission on the issue of electoral bonds. They treat this so casually. You can just say whatever you want and get away with it. One other thing that is that political parties are given a common symbol. So therefore, political parties are part of the instrumentalities of the state, and this has been held by this court. And even the CIC has held that political parties are public authorities under the Right to Information Act. The Association for Democratic Reform. Now, this was a very, very important case, my lord. I have quoted it here also, because this was the case where they mandated the disclosure of assets, liabilities, criminal antecedents, and educational backgrounds of candidates contesting election by means of an affidavit. And here the important thing is that they said that this flows out of Article 19(1)(a) rights. And when the government tried to overturn this by means of a legislation, that legislation was struck down on the ground that this is violating fundamental right of the citizens to know about candidates. And I submit, my lord, if the citizens have a right to know about candidates as to what are their assets, liabilities, what are their criminal antecedents, etc., by way of an affidavit, then equally or more importantly, citizens have a right to know about funding of political parties. Who's funding them? Well, political parties are playing a very important role in our democracy. They get a common symbol, they contest as a party, they form the government, they have given a right under the 10th schedule for disqualification of those who flout the party's mandate, etc., as to how to vote, and so on. So therefore, if citizens have a right to know about candidates, about their assets, liabilities, etc., they certainly have a right to know about parties as to who's funding them.
In a nutshell, Mr. Bhushan, your argument is the citizens must know what are the sources of fund of a political party.
Yes, because
that is in larger public interest.
Not just in larger public interest, it's the citizens.
Or there will be always a conflict which will come up. Some people will say it may have its own repercussions. But it's in larger public interest. And therefore it will be covered by the Article 1A, 19(1)(a).
Yes, and as contrary to what the government is arguing, they are saying that there are reasonable restrictions which can be imposed under rights under 19(1)(a). But those reasonable restrictions, firstly, they have to be reasonable, proportionate. Secondly, they have to be covered by one of the 6-7 things which are mentioned there, public order, etc., etc. Obviously, my lord, the funding of political parties cannot be covered by any one of those grounds which are mentioned in 19(2) as grounds on which restrictions can be imposed on this fundamental right under 19(1)(a). So therefore, my lord, and moreover about funding of political parties, there is also this problem. If I know that this party is being funded by companies who are getting benefits from this political party, then I know that this particular party is corrupt. because it is essentially getting a quid pro quo. And I suspect, and I'll show the figures. The figures about electoral bonds show that number one, they are almost all in denominations of 1 crore. So they are being largely purchased by corporates, etc., companies. Number two, they are essentially only being given to ruling parties. Bulk goes to the ruling party at the center, more than 50%. Remaining go to ruling parties in the states. And virtually nothing by way of electoral bonds goes to parties which are not ruling parties, either in the center or the state. And today, my lord, this electoral bond forms the bulk of the political funding of parties. So therefore, by making this non-transparent, you are defeating a very important right of citizens to know about who is funding these political parties, where are they getting their money from, whether this is tainted money, whether this is black money, whether this is laundered money, whether this is shell companies, through shell companies, whether whatever. So therefore, all that is being defeated. Therefore, my lord, this will clearly violate Article 19(1)(a) rights, and this 19(1)(a) right to information about public functionaries, public
Let's go to the next legal ground.
Yes.
19(1)(a) you have now indicated.
Yes. One judgment which I have not mentioned in my written submission, which I wanted to show, is the judgment of Justice Chagla of Bombay High Court. Very, very important judgment. That's the citation is AIR 1958 Bombay, page 155. This is an important judgment. Actually, my lord, though it came fairly early in our constitutional history, but you can see how prescient Justice Chagla was, even in 1957 when he delivered this judgment. This was a case where one of the Tata companies wanted to amend its articles of association to be able to give donations to the Congress party.